Who may exercise police power? The power is inherently vested in the legislature. However, Congress may validly delegate this to the President, to administrative bodies, and to lawmaking bodies of local government units. Local government units exercise the power under the General Welfare Clause. While police power may be validly delegated to the President by law, RA 6939 and PD 260 as amended do not authorize the President or any other administrative body to take over the internal management of a cooperative. Accordingly, Memorandum Order Number 409 issued by the President constituting an ad hoc committee to temporarily take over and manage the affairs of Canureco is invalid. From the case of Camarines Norte Electric Cooperative versus Torres, 1998. Unlike the legislative bodies of local government units, there is no provision in RA 7924 that empowers the Metro Manila Development Authority or MMDA or its council to enact ordinances, approve resolutions, and appropriate funds for the general welfare of the inhabitants of Metro Manila. Thus, MMDA may not order the opening of Neptune Street and Bel Air subdivision to public traffic as it does not possess delegated police power. From the case of Metro Manila Development Authority versus Bel Air Village Association. While Section 5 sa paragraph F of RA 7924 does not grant MMDA the power to confiscate and suspend or revoke driver's licenses without need of any other legislative enactment, the same law vests the MMDA the duty to enforce existing traffic rules and regulations. Thus, where there is traffic law or regulation validly enacted by the legislature or those agencies to whom legislative power has been delegated, the City of Manila in this case, MMDA is not precluded. In fact, it is duty-bound to confiscate and suspend or revoke driver's licenses in the exercise of its mandate to transport and traffic management, as well as the administration and implementation of all traffic enforcement operations, traffic engineering services, and traffic education programs. From the case of Metropolitan Manila Development Authority versus Garin. By designating the MMDA as the implementing authority or implementing agency, the President overstepped the limits of authority conferred by law. The case of MMDA versus Veron Transportation 2007. What are the limitations for the valid exercise of police power? 1. Lawful subject. The interests of the public in general, as distinguished from those of a particular class, required the exercise of the power. This means that the activity or property sought to be regulated affects the general welfare. If it does, then the enjoyment of the rights flowing therefrom may have to yield to the interest of the greater number. From the case of Velasco versus Villegas, Taxi Operators versus Board of Transportation. In Lim versus Paking, it was held that PD 711, which expressly revoked all existing franchises and permits to operate all forms of gambling, including high alay, issued by local governments as a valid exercise of police power. Gambling is essentially antagonistic to the objectives of national productivity and self-reliance. It is a vice and a social ill which the government must minimize or eradicate in pursuit of social and economic development. In Miners Association of the Philippines versus Factoran, it upheld the validity of the admin orders number 57 and 82 of the DENR Secretary, which effectively converted existing mining leases and other mining agreements into production sharing agreements within 1 year from effectivity, inasmuch as the subject sought to be governed by the question orders is germane to the objects and purposes of Executive Order 279, and that mining leases or agreements granted by the state are subject to alterations through a reasonable exercise of police power of the state. In Pollution Adjudication Board versus CA, the Supreme Court held that ex parte cease and desist orders issued by the Pollution Adjudication Board are permitted by law, and regulations in situations such as stopping the continuous discharge of pollutive and untreated effluents into the rivers and other inland waters, The relevant pollution control state and implementing regulations were enacted and promulgated in the exercise of the police power. The ordinary requirements of procedural due process yield to the necessities of protecting vital public interests through the exercise of police power. Second limitation for the test of valid exercise of police power is lawful means. These means or the means employed are reasonably necessary for the accomplishment of the purpose and not unduly oppressive on individuals. The case of Inot versus Intermediate Appellate Court, Balakwit versus Safe Eye of Agusan del Norte, and Tablarin versus Gutierrez. Police power concerns government enactments which precisely interfere with personal liberty and property to promote general welfare or common good. Although review of the facts and circumstances leading to the issuance of DOLE Order Number 3, establishing various procedures and requirements for screening performing artists as a prerequisite to the processing of any contract of employment by POEA, shows that the assailed order was issued by the Secretary of Labor pursuant to a valid exercise of police power. From the case of JMM Promotion and Management Incorporated versus the Court of Appeals. However, Section 2 of Comelec Resolution numbers 2772, which mandates newspapers of general circulation in every province or city to provide free print space of not less than one-half of the Comelec space, was held to be invalid exercise of police power in Philippine Press Institute versus Comelec, there being no showing of the existence of a national emergency or imperious public necessity for the taking of print space, nor that the resolution was only reasonable and calibrated response to such necessity. This was held to be an exercise of power of eminent domain, albeit invalid, because the Comelec would not pay for the space to be given to it by the newspapers. In City Government of Quezon City versus Iricta, the Quezon City ordinance, which required commercial cemetery owners to reserve 6% of the burial lots for paupers in the city, was held to be an invalid exercise of police power, but was instead an exercise of power of eminent domain, which would make the city liable to pay the owners just compensation. The proper exercise of police power requires compliance with the following requisites. A. The interest of the public generally, as distinguished from those of a particular class, required in the interference by the state. And B. The means employed, or lawful means employed, are reasonably necessary for the attainment of the object, sought not unduly oppressive upon individuals. An ordinance aimed at relieving traffic congestion meets the first standard, but declaring bus terminals as nuisances per se and ordering their closure or relocation contravenes the second standard. From the case of Lasana Grand Central Terminal versus JAC Liner. In Cabrera versus Lapid 2006, the Supreme Court upheld the dismissal of the Office of the Ombudsman by the Office of the Ombudsman of criminal charges against respondents, local government officials who had ordered and carried out the demolition of a fish pond, which purportedly blocked the flow of the Pasak River in Sasmuan, Pampanga. The court agreed with the findings of the Ombudsman that those who participated in the blasting of the subject fish pond were only impelled by their desire to serve the best interests of the general public. Additional limitations of police power when it is exercised by the delegates being the president, administrative bodies, and lawmaking bodies of the local government units. A. Express grant by law. So there should be an express grant by law for local government units. B. It is within territorial limits for local government units, except when the exercise to protect water supply. And C. It must not be contrary to law. Activity prohibited by law cannot, in the guise of regulation, be allowed. An activity allowed by law may be regulated but not prohibited. From the case of City Government of Quezon City versus IRICTA. In the case of Solicitor General versus Metropolitan Manila, Tatel versus Municipality of Virac, and Magtahas versus Price Properties, the Supreme Court declared that for municipal ordinances to be valid, they must be 1. Must not contravene the Constitution or any statute. 2. Must not be unfair or oppressive. 3. Must not be partial or discriminatory. 4. It must not prohibit but may regulate trade. 5. It must not be unreasonable. And 6. It must be general in application and consistent with public policy. In City of Manila versus Judge Lagyo, the Supreme Court declared as an invalid exercise of police power the City Ordinance Number 7783, which prohibited the establishment or operations of businesses providing certain forms of amusement, entertainment services, and facilities in Ermita Malate area. Concedingly, the ordinance was enacted with the best motives, ensures the concern of public for the cleansing of the Ermita Malate area and of its social sins. Despite its virtuous aims, however, the enactment of the ordinance has no statutory or constitutional authority to stand on. Local legislative bodies cannot prohibit the operation of sauna and massage parlors, karaoke bars, beer houses, nightclubs, day clubs, super clubs, discos, cabarets, ball halls, motels, and inns, or order their transfer or conversion without infringing the constitutional guarantees of due process and equal protection clause, not even in the guise of police power. The authority of a municipality to issue zoning classifications is an exercise of police power and not the power of eminent domain. A zoning ordinance is defined as a local, city, or municipal legislation which logically arranges, prescribes, defines, and apportions a given political subdivision into specific land uses as present and future projection needs. The case of Pasong Bayabas Farmers Association versus CA, 2004.